We have been researching the laws around secession for years. I've personally been doing it for a decade. We were very familiar with the court case Texas versus White, which says that secession is legal through consent of the states, quote, consent of the states, and is illegal unilaterally. And for a while, we thought that those are the only Supreme Court cases on this. Recently, we found a few more Supreme Court cases that touch on the subject of secession. I wanted to share that with you because we've never heard this before and nobody's ever provided this information to us. So we'll make sure that you're educated. And we're also going to provide a legal interpretation by a lawyer on what Abraham Lincoln meant regarding secession. We'll cover all that in a second. No one's going to cover the legal arguments around secession in as much detail as us here at CalExit. We'll see you in just a second. We have long talked about Texas versus White. Texas versus White is the only Supreme Court case to actually directly deal with secession. And it says that secession is legal with, quote, consent of the states. Consent of the states has never been defined. When I talked to lawyer Sean McBride, who can practice in 12 different states, including California and Texas, and I said, given that consent of the states was never defined in 1870, when the Supreme Court talked about Texas versus White, and given that the amendment process had been around for 100 years before, if they didn't use the word amendment, how can we assume that's what they meant? You said consent of the states is required for a state to secede in Texas versus White, argued in the late 1870s. You did not say an amendment is required for a state to secede. In American law, there's something called the plain language rule, which means you're supposed to say what you mean. So if you said consent of the states is a way to get out of the union, but did not say the amendment, maybe you didn't mean the amendment process because you didn't say it, and because everyone's known about the amendment process for over 100 years. If the amendment process was the only way to achieve consent to the states, why not just say that? Just say, hey, the only way out is the amendment process. That's not what they said in Texas versus White. They said the only way out is consent of the states. They never used the word amendment. Why not use the word amendment if that's what you meant? It's been around 100 years, and there's a plain language rule of law. Maybe because you didn't mean that it had to be an amendment. It could have just been some general form of consent. That's backed up by legal professor Erwin Chemerinsky, founding dean of two separate University of California law schools, who said that a simple majority vote allowed California to become part of the union. So maybe a simple majority vote could allow California out. 51% vote of Congress. That's nowhere near the threshold for an amendment. So why is a constitutional scholar, one of the most preeminent, one of the most legally cited scholars in all of America, Professor Erwin Chemerinsky, not saying that you have to do an amendment process, but saying a simple 51% vote of Congress could get you out, and that could qualify as consent? Maybe it's because consent was never defined, even though they knew the amendment process existed, even though it had been around 100 years, and they chose not to say it. That's the background you need to know. Now, looking into those things, we have found some other Supreme Court cases recently that relate to secession. We're going to cover them here. We've never heard about these before, but we'll cover them right now. So the U.S. Supreme Court in Lane County versus Oregon, 1868, and the U.S. Supreme Court Williams versus Bruffy, 1877. Let me show you those cases now. Here we go. Okay, Williams versus Bruffy, 96 U.S. 176, 1877. Here's why this is related to secession. De facto governments of two kinds are considered, such as exist after it has expelled the regularly constituted authorities from the seats of power in the public offices and established its own functionaries in their places so as to represent, in fact, the sovereignty of the nation. As far as other nations are concerned, such a government is treated as, in most respects, possessing rightful authority. Its contracts and treaties are usually enforced. Its acquisitions are retained. Its legislation is, in general, recognized, and the rights acquired under it are, with few exceptions, respected after the restoration of the authorities which were expelled. 2, such as exists where a portion of the inhabitants of a country have separated themselves from the parent state and established an independent government. The validity of its acts, both against the parent state and the citizens or subjects thereof, depends entirely upon its ultimate success. If it fails to establish itself permanently, all acts perish with it. If it succeeds and becomes recognized, its acts from the commencement of existence are as upheld as those of an independent nation. So what the Supreme Court said in Williams versus Bruffy was they had to admit that they seceded from the English government, and they did not have a legal right under English law to do that. But they did it, and now they're a recognized government. So in order to make sense of that, the court had to say, okay, well, if you defy the parent state and you actually fight them off or somehow retain independence without warfare, and you're able to keep yourself independent, then I guess you're an independent country and everything you did is legal. And the reason they had to say that was America seceded from England. America was part of England. There was no law in England to secede. They just did it. The king said it was illegal. They did it anyways. And if they had been defeated, well, there never would have been an America, and the Declaration of Independence wouldn't matter, and neither would the Constitutional Congress or the Constitution. But they won, and therefore the Declaration of Independence does matter, and the Constitution does matter. And so what they're saying is that if you somehow hold on either through warfare or not warfare, maybe economic sanctions and whatever, and you're able to maintain yourself as an independent nation, you are an independent nation, and that is recognized, and that's the law, and you can do whatever you want. So they had to admit that in Williams versus Bruffy, 1877, because they had to explain how they had this position on the Civil War where the South seceded and it was illegal, but they also seceded from England when it was illegal. And this is how they made sense of all that, was if you win, you're in. And if you don't, you lost. That's what the law says. So when we look at if you can secede and be successful, it comes down to, did you pull it off or not? That's what the law says. So most people don't know that. But basically, the American law says, hey, if you secede and you pull it off, you're good. There's no real rules or criteria to secede or be recognized. It's just if you pull it off, great, you're in. This is the only Supreme Court case on this, and that's what it says, and it's never been challenged or revisited. So let's look at the Supreme Court. Lane County versus Oregon, 1868. The people of the United States constitute one nation under one government, and this government, within the scope of the powers with which it is invested, is supreme. On the other hand, the people of each state compose a state having its own government and endowed with all the functions essential to a separate and independent existence. The states disunited might continue to exist. Without the states in the union, there could be no political body as the United States. So what they're saying is the states actually might be able to secede from America and continue to exist. But without the states, America doesn't exist. So essentially, they're agreeing that the states exist independently of America. The states exist within America as a union, and if the states leave, they continue to exist, but America doesn't. So the states seem to be these preternatural power units, where the states existed before the union, the states will exist after the union, and the states could exist independent of the union. That's what the Supreme Court case says. So America may not last, but the states will. Supreme Court case said that in Lane County versus Oregon, 1868. Okay, let me show you those cases. So this is Williams versus Bruffy, 1877. Not sure where that key phrase was, but it's in here. Here we go. So yeah, if you pull it off, you're in. If you don't, you're not a nation. But if you do succeed, then you're independent. Williams versus Bruffy, 1877. Lane County versus Oregon, 1868. Let's see. Raise your hands. Yeah, subsequent 3 acts, subsequent treasurer. The case now brought to air. Oh, here we go. Case. Sorry. Oregon Constitution made an answer to the circuit court chief justice at court. 1 second. Yeah, no. There you go. States exist independent of the U.S. They existed before. They will exist afterwards. They will always exist, but the Union may not. There's the phrase. Lane County versus Oregon, 1868. And then, of course, here's our favorite, Texas versus White, 1868. So look, all these were decided around the same time. 1868, 1868, 1877. So here's Texas versus White, set the precedent. And then these court cases come around the same time, all argued by Chase, all around the same time. So that's that. We covered these 2 cases, this one, and this one, and this one. And now we want to cover to this. This is a legal understanding that we have had and that I've argued with Sean McBride. And I said that, Salmon Chase was the Supreme Court justice who presided over Texas versus White. Salmon Chase was directly appointed by Abraham Lincoln, the president of the Civil War. Abraham Lincoln said in his first inaugural address, his very first speech after being elected president, that he would have to accept states seceding if there was some vote by everybody to allow them to go. So if most people or majority or everybody said, hey, these states have the right to go, he could do nothing to keep them in the Union, and he would have to go along with what the people said. He said that in his inaugural address. But there never was a vote for the states in the South to secede. The Southern states literally just left the federal government, didn't apply for a vote, and started shooting at them. Lincoln was saying, if you applied for a vote and there was a vote, I would have to accept your right to secede. That backs up what Salmon Chase said in Texas versus White, that you cannot unilaterally secede as the South did, but you could secede with consent of the states, some form of consent. That's also what Lincoln said in his first inaugural address. We have a lawyer now who's backing that. Akil Reed Amar, the University of Illinois College of Law, where Lincoln was from, in a speech, in an essay called Abraham Lincoln and the American Union. Let's cover that right now. Let me do share screen. The consent to the states requirement could, however, be taken to mean the consent to a constitutional amendment approved by 3/4 of the states as set out in Article 5 of the Constitution. This approach is one suggested by Abraham Lincoln in his first inaugural address. Akil Reed Amar has suggested that Lincoln may well have had no alternative but to accept the legality of secession supported by the people as evidenced by a legally non-binding national referendum. This is because in a regime based upon the people's ultimate sovereignty, such a referendum would have carried great moral weight with those government actors. Indeed, in Texas versus White, Salmon Chase echoed Abraham Lincoln's speech. Yeah, so that's what they're saying is that. Here, let me show you that essay. So this is the essay. This is the I think peer-reviewed document. This is like a legal argument. The David C. Baum lecture, Abraham Lincoln and the American Union. Let's bump that up. Sorry. By Akil Reed Amar. And this is where he points out, Abraham Lincoln said in his inaugural address, if the people wanted and voted for the states to secede, he would have to allow them. He appointed Salmon Chase. Salmon Chase ruled in Texas versus White that states could secede with consent. So what this lawyer is saying in this law document from a university that's peer-reviewed is that Abraham Lincoln and Salmon Chase both agreed that you could secede with a form of allowable vote. The reason that Lincoln didn't allow the southern states to secede was because they quit the federal government, didn't ask for a vote, and then started shooting at the federal government. That's radically different than approaching the federal government and saying, we want to have a vote to secede. and then Congress votes and a majority approved, and then they left. Nothing like that happened at all. And Lincoln was saying, if you'd done it that way, maybe I'd have to let you go. And then Salmon Chase basically backed that up. And this lawyer is basically saying, if you look at Salmon Chase and Abraham Lincoln, basically the legal understanding from the people who were the chief arbiters of the Civil War is that you could leave with consent. Maybe an amendment or some form of consent. Again, Salmon Chase doesn't say amendment. He just says consent, and the amendment process had been around a very long time. So that's that. I need to point out one last thing, though, that's interesting. So in that essay by Rita Marr, there's this paragraph which I found interesting. Notwithstanding the fundamental importance of the issue dealt with the case, it appears that the community of law teachers in the United States has generally followed the approach adopted by Thomas M. Cooley in the last decade of the 19th century when dealing with the issue of secession. Cooley eschewed the theoretical issues involved with secession and chose to accept that the United States was an indestructible union simply because the Supreme Court said so in Texas versus White. On this basis, Texas versus White is thus only worth mentioning as a footnote, which is exactly where Cass Sunstein cites it as authority for assertion that no serious legal scholar or politician now argues that a right to secede exists under American constitutional law. So there was this guy called Thomas C. Cooley who basically said Texas versus White says secession is illegal, period. He was wrong. Texas versus White says secession is legal with consent. He didn't say that. He said it's just indestructible union, the end. This guy basically set up a preference, a culture, a standing in the American legal profession to say that secession is illegal. Thomas M. Cooley got this wrong. Texas versus White does not say you can't secede. It says you can't secede unilaterally. Let's take a look for Thomas M. Cooley. Oh, here we go. Here we go. Let me show you. Yeah, this basically backs it up. Thomas M. Cooley, 1824 to 1868, was the 25th Chief Justice of the Michigan Supreme Court between 1864 and 1885. So he was a Michigan Supreme Court justice around the time that these cases of Texas versus White were being decided. He was the dean of the University of Michigan Law School, Western Michigan University, just as the State Bar of Michigan is Michigan Legal Milestone. So he's very well thought of in Michigan. He was a representative for New York. He was a Republican, so he backed Lincoln. And so Michigan is in the north, okay? And this guy's a Republican, and Lincoln was a Republican, and the Republicans wanted to defeat the South. And Lincoln said the states, couldn't break apart. So this guy's saying, oh, secession's completely illegal because Texas versus White said it. And yeah, he was a Supreme Court justice in Michigan around the same time as Texas versus White was decided, but he's biased. Okay, the guy's a Republican, and he's from the North. So he's totally in the pro-Lincoln camp. And he's the one that said, Texas versus White says you can't secede. End of story. Why would he say that? Because he's a Republican who backed Lincoln, and they hated the South seceding. So he used his personal bias to make an assumption about the law. And basically, he's the reason why lawyers today don't think that secession is legal, because he kept pounding it home from 150 years ago that it's not. And he is completely biased, a Republican from Michigan who wanted to back Lincoln. And so I wanted to point out, we have this history that law professors say, oh, nobody's going to listen to Texas versus White. The reason they do that is that other law professors told them that. The reason they do that is you go back to this guy 100 years ago who incorrectly interpreted Texas versus White. And I've seen this bias because I've argued with lawyers and they go, you can't argue Texas versus White. We can just throw that out. And I go, okay. So let me ask you a few questions, lawyers. Does American law work on case law or common law? And you'll see them. A lot of lawyers don't know this answer because it deals with the history of law versus like law as it understands now. They're like, what? And they go, America works on case law, stare decisis, meaning you cannot make any legal argument unless you can cite previous legal precedents. That's why lawyers go to school, to study case law. And when I go, so you can just ignore the only Supreme Court case on secession under an entire legal administration that says you can't argue anything without citing previous cases? And every single lawyer I said that to you does this. Oh, were they talking to me? No, I think that was for you. Every time. Every time. We don't need to listen to Texas versus White. We can throw it out. Oh, so you can disregard the only case that set up a legal precedent in America, which the entire legal foundation is based upon case law and legal precedent, and they get real quiet. And that's what I mean, the bias. I'm not a lawyer. I should not be able to poke apart lawyers with a simple legal logical question. The reason I am is that they're biased. They're humans. They were taught bias. We think lawyers are these perfectly unemotional people with no human biases. And what does the law say? I will go off that. Not true. They're humans. And they were biased in law school to believe Texas versus White says one thing when it doesn't, because somebody was biased 150 years ago, and that bias is continually taught in legal professions. And that's why lawyers look stupid when they say we can ignore Texas versus White. And then I go, oh, so you're saying you can ignore stare decisis. And then they realize they said something stupid and they all shut up. Why does that keep happening unless they're all making logical mistakes? I should not be embarrassing lawyers or correcting them. I've done it many times on this, and they all fall for the same thing. I don't need to cite Texas versus White. Great, we can ignore legal decisis, stare decisis. That's their response. That means you've never thought about this issue. You don't have a legally articulated argument. You had assumptions, and you were never challenged with it. Backs up what they're saying about bias. Texas versus White does say you can't secede, but if we turn to lawyers, they're not going to back us up because they have been biased incorrectly. All right, that's the show. We'll take a look at the comments. If they're relevant, we'll cover them. If they are not, we will not. Let's see. Yeah, we are seeing Texas versus White part 2. Yeah, I mean, American law doesn't make sense because they'll say this is the ruling once, and then they can just change the ruling. So that happens all the time. The Supreme Court can do that. They can overturn legal precedent. And once the Supreme Court does it, that's the new law. Yep, America left illegally. California wants to do the same thing. Other countries leaves illegally and are still independent and recognized. Yes. Yeah. So we had a lawyer, an interview with Sean McBride, and he goes, yeah, you could argue that because Texas versus White says consent and not the amendment process, and the amendment process was known for 100 years, and this is the plain language rule under the law, that since they did not say amendment, maybe they didn't mean it had to be exclusively the amendment. Sean McBride said that's an argument. He's a lawyer who can practice in 12 states. We did that interview with him last month. So, more to know about Texas versus White, relevant legal cases connected to it saying you can secede if you pull it off, and the states can survive independent of the union. And then legal scholars under peer-reviewed articles saying that Abraham Lincoln knew you had the right to secede with consent. Same thing backed up by Selma Chase, the guy that he appointed. Well, that's it. Hope you appreciated this. No one is providing this in-depth legal knowledge. Nobody that allows you to argue with lawyers and prove that they're wrong. We're the only people doing it anywhere. I think that says something.